SJC-10018, Commonwealth versus Joseph Spinucci.
Good morning, Mr. Hanafy.
Good morning. May it please the court, I am Joseph Hanafy. I represent appellant Joseph Spinucci. The trial evidence supports our position that provocation arose in this case from sudden combat.
Isn't the only evidence that, at best, Mr. Sullivan, the decedent, jumped your client? Nothing.
That is partly correct, Your Honor. I submit that there's a more complicated overview of this case, that it is true that the allegation is that Ryan Sullivan jumped Joe Spinucci. But our position is that he didn't just jump Joe Spinucci, he jumped him from behind.
And that he was able to throw him off right away.
He was able to throw him off. We don't know how long it took him to throw him off. We know that Ryan was on Joe's back at least for enough time for Danielle LeBlanc to see that and to see that he had to throw him off. And so I submit that that's a moment of sudden combat. This was at dawn.
What threat did the unarmed Sullivan present by jumping on his back?
That is
threat of serious harm, let's say.
I'm sorry?
What threat of serious harm? That's what the cases require.
Well, yes, it is. But I would also say that jumping on someone's back at night in a public location causes the person who is jumped to devolve into a position of fear.
By this point, he had already stabbed Billy, and the co-defendant had stabbed Jules. So you're saying at this point when the third person jumps him, he's in fear? He's already got a knife out.
No, if I may try to answer that question, Justice Lank, I submit that the facts in the trial record support the position that Billy was, first of all, the trial judge recognized that Joe was provoked by Billy's violence against Claudine.
Yes, as to Billy.
As to Billy. And so following that, Billy runs, Billy trips and falls. Joe is there with him.
And stabs him in the back.
On the ground. Now, Billy is on the ground, and Joe stabs him one time where he had to be closer than arm's length to Billy, who was on the ground. Yeah. This is from Billy's testimony. Now, Billy also says that when he got up, there was no one near him. I submit that a reasonable interpretation of the facts established that Joe, having been provoked, catches Billy because he fell. He's on the ground. Joe stabs him once. And then Joe lets Billy go. Billy gets up, and Van, having stabbed Jules, takes off after Billy, who Joe let go. At some point near that sequence, Ryan jumps Joe in sudden combat from behind. I submit that you can't attach yourself to someone's back by facing your target. It was a sudden, violent onslaught in a dark location, in a location where Joe Spinucci is not familiar with. He had already been provoked once. Now, I'm not saying that Billy's provocation applies here. What I'm suggesting is that Ryan's provocation of Billy warranted a provocation instruction. All we're asking is that a trier of fact make the determination whether Joe was provoked a second time by Ryan.
But does Justice Link said you need to have something about that there was a threat of serious harm being produced by Ryan.
Yes,
correct?
I understand, Your Honor,
I don't
that
think there's, yeah, so he jumps on his back, but, well, we know afterwards he had no weapons on him, and I don't, so how do you get to the multiple knife?
well, I think it's a complicated sequence of the overlap of provocation law and the application of it to the facts of each case.
And where does it turn into excessive use of force in self-defense? Is that
I'm sorry?
Are you suggesting it's excessive use of force in self-defense?
No, I'm not. What I'm suggesting is that the case law reminds us that provocation can arise from the application of force by the hands alone or by the legs alone. That would be Butcher and Keogh remind us of that. So what we have at this moment, I mean, if you think about what it takes to get onto someone's back, that's an act of violence. And that number one. And then number two, what does it take to stay on someone's back? It takes violence.
We don't know how long he stayed on his back. You just said so.
We don't know how long he stayed on his back, but we know it was long.
We know he threw him off.
I'm sorry?
And we know he threw him off. And then...
That is correct.
And the stabbing took place by at least one, if not two people.
Yes, that is correct. But I think the case law recognizes that once provocation arises in the defendant, that you must look at the case, look at the facts, and make a reasonable inference. Was there a provocative moment? And all reasonable inferences must resolve in favor of the defendant. If any view of the evidence supports the giving of a provocation instruction, then a provocation instruction must be given.
I guess that's getting to my question. Is it just the fact of a provocative moment, as you say, or does one take into account the nature of the provocation in relationship to the kind of force used by the defendant?
I think there's less connection between the provocation and the amount of force used. We have cases, again, in Butcher and Keogh, where slight but sufficient provocation brought about multiple stab wounds. In Butcher, the individual was, the sequence is that there were two groups of people, strangers. One is driving a car. The defendant stands in front of the victim driver of the car and blocks his egress or access just to be a pain. The victim drives off, turns around and comes back, gets out of the car and kicks the defendant once. Because of the setting, because of the circumstances, but the judge refused to give a provocation instruction, and that case was reversed because there was sufficient evidence of provocation to warrant a provocation instruction. It's not sufficient provocation to demand a manslaughter verdict. It's to give the trier of fact the opportunity to make that determination. And I think what we have here is not only do we have an instance that is like Butcher in the sense of a single act of provocation, we have that in our case. There are two. Joe was provoked by two different people. But I'm not asking the court to recognize that that Billy's provocation is part of what I'm arguing here. I'm arguing here that Ryan's provocation was sufficient under the law and under the inferences that must be applied to give to warrant the provocation instruction. And I would also say that it's the setting It's the nature of the provocation or of the conduct, the violence committed, that brings us to the whole notion, the whole concept of provocation that goes back as far as the Webster case. In Webster, we are told, reminded that it says that when every man when assailed with violence or great rudeness inspires the defendant with a sudden impulse of anger and in an absence of time for cooling, that the violence that erupts is done through the heat of blood and the violence of anger. And though while it cannot be excused, if the jury so finds, then there has to be culpability, but not to the level of murder.
So what degree?
May I direct you to one other factor here? According to the medical examiner, the deep fatal wounds could not have been inflicted by the defendant's 3-inch knife. So
That
what
is
are you
correct.
making of that in this appeal?
Well, I thank you for the question, and that will hopefully afford me an opportunity to move into the business that I brought to the court on the question of the Berry case. But just a moment before getting to that, I would like to also just say that the key, and then I'll move on because this is what I was hoping to get to with the questions, but the Keogh case reminds us that if the conditions are such that a trier of fact could make out this sequence, then a manslaughter instruction at least ought to be given. And that is that if it's a senseless encounter between two groups, that if the defendant had the weapon and didn't go off to to retrieve a weapon and come back thereby having cooled off, that if the victim is grabbed in sudden combat, then heat of passion ought to, the question of fact ought to be, does the heat of passion negate malice? And in the Keogh case, this court affirmed a trial court's reduction of second-degree murder to manslaughter because those conditions were ripe for a recognition that provocation controlled that.
But if the facts, well, let me give you a scenario which may or may not, which be what happened here. But if the defendant has just stabbed Billy and maybe standing over Billy, and somebody then jumps on his back, arguably to prevent further stabs, and that may not have been what the evidence plays. I have not gone to the transcript. Is that a mitigating element if he then goes on to stab the person who jumped on his back?
Well, if I may answer that, number one, there's no evidence in the transcript that such was the case. The evidence, the inferences that can be drawn, are that Billy ran off, Van chased him, and at some point, Jules jumped, strike that, Ryan jumped Joe. And so there was no interference.
So it was not done to prevent him from further stabbing.
That's correct.
But it was done after he had stabbed his friend.
That's correct.
And does that matter in terms of mitigation?
I submit that that's something that the jury should have to consider, because we know, this is somewhat complicated, because we know that the judge gave a provocation instruction because of Billy's conduct towards Claudine. Therefore, Joe had some mitigating reasons for assaulting Billy,
Right. So,
but he did only once with a superficial wound. which, if I may, so there's no evidence that what you're proposing, in fact, is what happened. And secondly, the trial judge made no finding of that. In a pro se motion, there was no finding that there was any sort of conduct by Ryan that was somehow to be perceived in defense of Billy. There was no facts in the record, there was no trial evidence, and there was no finding by the trial judge. So, having said that, if I may now respond to the question from Justice Hines, I cited to the Berry case because while Berry is not a joint venture case, the concurrence in Berry invited me to consider the following, that where you have a situation where Joe is called into sudden combat with Ryan, then looking at the surrounding circumstances, we know that this was a completely chance encounter after the fireworks had ended. It was completely by chance. Danielle encounters Billy by chance, chastising him for selling drugs to her younger brother. This was not a plan of any kind whatsoever. And then Ryan and Jules line up with Billy. This was also not part of any conceived plan that the defendants could have conceived of. And then because of, I submit, Berry applies for this reason, that because of the weapon, because an inference of malice instruction was given against the defense in the trial, because of the inference of malice.
Your client had a weapon also.
I'm sorry?
Your client had a weapon also.
Yes, but that's not dispositive of the cases that I'm going to the Berry case, if I may try to explain that. I'm saying because of the inference of malice instruction, which is standard procedure, I'm saying because of that, because Joe was provoked, because that Van was not called into the encounter with Ryan by Joe, that because of the instruction, the jury ought to have been instructed to find that whether Joe knew that Van had a 6-inch blade in response to Justice Hines, because his was only a 3-inch blade, and the 6-inch blade is what
You're not arguing he didn't know that he had a knife. You're just talking about he didn't know how long a knife he had?
No, I'm arguing both, Your Honor. I'm arguing that there's a hearsay argument that I will hopefully get to. But what I want to do is just say, justify my request that Berry be considered here is because Joe didn't know that Van had a 6-inch blade. There's no...
What point did he not know? He stabbed Billy. And at the same time, it seems like Van is stabbing Jules.
Correct.
So, and they're
Where's
there
that
together.
physically in relation to Billy?
Their feet or yards apart.
Right, and so you're saying, so before he turns to stabbing Ryan, the decedent, he has to know that Van has a knife. Because Van has just finished stabbing Jules.
I submit that after Joe let Billy go, that when Ryan jumped Billy, that Joe was completely preoccupied with him. There is no evidence in the trial record that Joe ever saw the blade. There's no evidence in the record that Joe knew that it was never shown to Joe. And so I'm asking that Berry be applied because in the joint venture sense, assuming provocation can warrant a new trial because a provocation instruction should have been given, Berry, because he was found guilty of extreme atrocity, cruelty murder, I'm suggesting that based upon the language of Berry, that because of the unique circumstances in this case, that somewhere along the line, a question of fact ought to be answered whether Joe knew Van had a 6-inch blade with him. And secondarily, whether he knew that Van would cause extreme suffering and a torturous death to please his girlfriend, which the evidence in the case shows that Van was out in some measure, if some occasion arose, that he was intent on stabbing someone to please Danielle, and I submit is outside of Joe's culpability, right. And so I invite the court to consider that if we get this far, that Berry ought to at least maybe warrant that in a joint venture setting, that a joint venturer ought to know whether his co-venturer is intent on committing extreme atrocity, cruelty, murder, and with what weapon.
All right, thank you.
And I thank you, and I rest on my brief at this point. Thank you very much.
Good morning. May it please the court. Fawn Bolero Anderson, Assistant District Attorney for Middlesex on behalf of the Commonwealth.
Before you get started, could just sort of procedural background. The defendant was also convicted of second-degree murder on a theory of premeditation.
No.
No.
Just second-degree murder generally.
I'm sorry.
Was a
Using jury slip. I mean, it doesn't make sense.
That's right. I believe there was a jury slip in this case, and they came back not guilty with regard to the deliberate premeditation, guilty with regard to the extreme atrocity and cruelty, and guilty on second degree generally.
Oh.
Well, wasn't the second degree one checked off under the deliberate premeditation?
That's what I thought too.
Well, it's the same thing. I mean, it would apply. The second degree would be the same, regardless of if it's a lesser included of first degree
The
or
jury slip is just,
extreme atrocity or cruelty.
Was any clarification sought from the jury as to what they had done?
No, and it's really not an issue before the court.
well, in theory,
With regard
it
to
could be an
Mal.
issue, because if there were to be a new trial, it's not clear to me whether the jury found the defendant not guilty of deliberate premeditation or simply didn't reach the issue.
I do believe they found him not guilty on deliberate premeditation.
Okay.
Based on the jury instructions.
How can you be guilty of murder second degree for deliberate premeditation?
It's just not the right way to do the
I
jury
mean,
slip.
the verdict form is a very strange verdict form. All right, but in any event,
Well, getting back to the
help
case,
me, help me with the core issue in the case, which is the reasonable provocation. I mean, it's sort of somewhat strange that in this particular case that the pushing of his girlfriend is viewed to be sufficient to get a provocation instruction with regard to the stabbing of Billy, but the victim's jumping on his back is not viewed as sufficient to get a reasonable provocation here. What degree of force or what degree of conduct do we say is enough to mitigate a subsequent killing? I mean, isn't that sort of the core issue, is the conduct that would mitigate a killing from first or second degree to manslaughter?
That's correct. So it's the Commonwealth's position, first of all, that the defendant was not entitled to a mitigating instruction with regard to the armed assault with intent to murder, which was the underlying charge for the defendant's conduct against Billy Ty.
He was or was not?
Was not. That's the Commonwealth's position. He wasn't entitled to that. He
that
got
the-
it nonetheless.
Is
And
that the only one that defense counsel asked for?
no, he asked for it also with regard to the murder, but if you look at the defendant's motion requesting that, the last paragraph of his motion states that the underlying evidence that supported his request was only Billy Ty's assault on the defendant's girlfriend. It had nothing to do with the
Didn't
jumping on
argue
the
the
back.
jumping on the back.
No, this was not requested by the defendant at trial because it was completely at odds with his trial strategy, and it wasn't supported by the evidence the Commonwealth suggests.
Why was it at odds with his trial strategy?
Because his trial strategy was the defendant claimed he had nothing to do with the attack on 2 of the 3 victims. He claimed his culpability only had to do with Billy Ty. He divorced himself totally from the attacks on Jewel Stevens and Ryan Sullivan, stating that his
But he didn't do them.
he did not touch them. He did not stab them. His co-venturer took that upon himself. He did not have the shared state of mind for those stabbings to occur. So that was his defense at trial. And it's hard to...
Right, but the judge was instructing on joint venture. I mean, I understand he was opposing that, but the judge was doing it. So why wouldn't it have been relevant?
Because he would have had to admit that he
No, he doesn't have to admit anything. He just has to ask the judge for an instruction on provocation.
Well, at the time, his request for the instruction on provocation was based on only Billy Ty's attack on his girlfriend. Had nothing to do with anybody jumping on his back. He denied that happened. He knew that he moved in limine to have testimony about someone jumping on his back excluded, so he knew it was going to come into evidence, yet he never pursued that as a reason underlying his request. And the Commonwealth suggests...
I'm sorry, the defendant moved in limine to keep out of evidence the fact that the victim jumped on his back?
That somebody jumped on his back. Yes, he moved in limine to keep that out of evidence.
And his reason for doing that was?
Speculation.
And so who put it in? It came in through Claudine?
It came in through Danielle.
Danielle, I mean?
The co-venturer's girlfriend stated when she was coming back up the scene where the stabbing was occurring, she saw somebody on the defendant's back, a male, and that the defendant threw him off, and that's what the trial evidence was limited to. That's it. There's no evidence of any reasonable fear or subjective fear on the part of the defendant in this case, which you would need in order to trigger a reasonable provocation instruction with regard to sudden combat. In this case, jumping on someone's...
I'm going to stop you there. I mean, how do you get... It's the defendant generally who's claiming that he or she, usually he, was provoked. The defendant doesn't always testify. How are you going to get into that I was scared without the defendant testifying?
Because the nature of the circumstances of the whole setting would justify it. And usually you do have a statement to the police. Like Acevito's a great case with regard to sudden combat. In that case, you have 2 groups of people who were together early in the night. There's a fight between the 2. There's a verbal exchange. They separate, and the party comes back. And then there's a physical fight where the defendant himself gets he's outnumbered. He's by a group of people. He's struck over the head. And then he, in turn, uses deadly force, swinging a knife, and ends up killing one of the group of people who are attacking him. And this case is far different from that. There is no fear. The defendant himself...
They fear, but isn't it sufficient if somebody says, I'm sleeping with your wife, and then he gets stabbed? Hasn't our case law said that would be reasonable provocation?
That's reasonable provocation based on heat of passion. We're talking about reasonable provocation based on sudden combat, where you have a physical component that is...
What about the case that Mr. Hennepy relies on, I don't know how to say it, Boucher or Boucher, which you don't cite, but what about that one, if you know?
That case is different from this case. This case is I suggest that you can't, even looking at the act alone, putting it in the defendant's, and not looking at the entire setting. Jumping on someone's back without striking a blow or anything isn't enough to throw the person off, turn around, and start stabbing him. What we have here is, that could have been one of the girls jumping on his back. It's all
Well, the judge, anyway, found that it was, in fact, Ryan.
Right, but in the defendant's state of mind, right? So he has to have there has to be a threat of serious harm. He just finished stabbing somebody. Somebody jumps on his back, and that, I suggest to you, is an attempt to defuse the situation. You can't view that as anything other. It's not someone jumping on the back and delivering a blow from behind. This is pulling someone away from the situation. That's all that jumping on someone's back is in this situation.
Well, you could view it differently. You could look at it as being attacked, I suppose. But there's no evidence of any hitting or use of a weapon or anything.
Right, no evidence that he was struck or blow.
And the judge disbelieved the testimony that he was choked.
That's correct. So at the motion for new trial stage, you can see it's a desperate attempt to get a second bite at the apple. The defendant is taking it's a pro se motion for new trial. The defendant is taking the evidence and stating a different set of circumstances. And we know that because at the motion for new trial stage, the notes from the defense attorney's first meeting with the defendant were submitted. And we know that what he told his attorney is the defense that was elicited, that they pursued at trial, that he had nothing to do with the attack on Jules Stevens or Ryan Sullivan. But we know, at the motion for new trial stage, all of a sudden he's saying he has to explain the cut on his fingers, and he has to explain why he then turned his weapon on an innocent bystander.
But it seems that there are at least two separate issues here. One is, based on the evidence at trial, was he entitled to a reasonable provocation instruction? And then the motion for new trial, I guess, says that there may have been additional evidence that the defense counsel was ineffective in not presenting?
That's right.
Which would have strengthened the claim for a reasonable provocation instruction, I gather. So we really have two separate related issues, but putting aside the motion for new trial, and focusing just on what the evidence was at the time. I guess the other question I would have for you is the one I asked your brother, I have some concern, I'm not sure not sure exactly how, but I have some concern with the idea that if I stab your buddy and then you come over and slug me for having stabbed your buddy, that now means that if I kill you, it mitigates my killing of you. After all, I had triggered the violence by the initial stabbing. But I don't know that I've ever seen a case which addresses that issue.
No, I haven't either, and that is a factor that I think that has to be put into the calculus. And if you look at, again, drawing on the Acevedo case, they do look at who starts the fight and when it turns physical. In this case, the defendant brought the knives to a fist fight. And not only that, he pursued the victims who were fleeing. I just can't overlook the fact that jumping on the back in this circumstance, again, is nothing more than an attempt to diffuse the situation, but taking your hypothetical into consideration where the victim in this case, the deceased victim, would deliver a blow for stabbing his buddy, which is even more than what we have here. There's no sudden combat from that because the combat has already started at the behest of the defendant. The situation in this case, we have, at all times, these three fleeing victims were outnumbered. It was 3 to 4. You have the defendant, his co-venture, and their two girlfriends, who we know took part in the attack. They not only started the confrontation verbally, they turned it physical when Claudine, the defendant's girlfriend, punched him, and then after the fact, they go over to the presumably Jules Stephen, and start kicking the body while the body's down on the ground after being stabbed. So at all times, these three victims were outnumbered, and not only outnumbered, but they were all unarmed. This is a classic extreme atrocity and cruelty case for that reason, because the victim was on the ground and by all accounts, the evidence would support that he was being stabbed while he was down on the ground.
Would it matter to you if the evidence was that the victim had slugged him from behind, as opposed to jumping on his back?
Yes. I would have to say, if there was evidence that the deceased victim had punched the defendant in the head from behind, it would have made a difference, because that action is completely different than the attempt to defuse the situation. That would be only escalating the situation.
Well, we don't know. I mean, you characterize his jumping on the back as the attempt to defuse the situation. I don't know whether that necessarily is based on at least, it's one thing if he's on top of Billy about to stab him again, but I gather there's at least some view of the evidence where that was not the case. Well,
you still have a defendant who set chase against fleeing victims. There's still victims who are fleeing, and the motion for new trial, Judge, rejected the defendant's claim that he saw stars and was being choked. So that's out of the calculus.
Gather there was no evidence of that. I mean,
Right.
all we have is Danielle.
So what the request is now based on is all speculation, and I don't think.
Well, no, we still have. I mean, put aside the motion for new trial.
No,
But to me, the more interesting issue is whether Danielle's testimony by itself was sufficient to trigger a reasonable provocation instruction.
And I maintain that it's not only because the act itself isn't enough, but especially when you look at the totality of the circumstances, that's where it certainly is not enough. And I submit that you can't ignore those other facts when you're deciding whether or not this defendant was entitled to a reasonable provocation based on sudden combat theory.
And the standard we give for a judge who faces this again is what? This distinction between jumping on one's back versus striking somebody?
I suggest it's a substantial, with regard to whether or not there was a threat of serious harm, that standard, or the substantial likelihood of miscarriage of justice?
Basically, when you're entitled to this instruction, I mean, it's a fine line that you're seeking to draw, and I wonder where you're drawing the line and whether the line is focused on whether it's a punch as opposed to a grab, or whether the issue is whether or not this is the type of conduct that the law says properly mitigates a killing to manslaughter. I mean, that ultimately is what is at issue here, is the law says some conduct by the victim mitigates the severity of the killing.
I think the standard is the threat of serious harm. And I would even suggest that some of the cases talk about a duty to retreat, and I know that bleeds over into the self-defense realm, but the cases still, when they do talk about sudden combat, have mentioned that there was a duty to retreat. And in this case, the defendant, if we believe the evidence from Danielle, we know that someone jumped on his back, presumably Ryan, based on the evidence, and then turned around and started stabbing him while he was on the ground. He was able to throw him off. There was no evidence. Danielle didn't testify that there was any struggle in between the point when someone jumped on his back and he threw him off.
She also testified to seeing him stab?
No, neither of the girls testified to having seen a knife at all. So what we know is that the defendant's girlfriend herself says that she saw the defendant and the co-venturer both over the body that was on the ground that was struggling. The feet were moving, and they were both were moving their arms, but she denied seeing any weapon. And we also have evidence that...
But I'm sorry, but they saw the blows that apparently were the stabbing.
That's right. She did see the blows.
That's Claudine.
That's Claudine. And we also know that Billy Ty's stepfather, who interrupted the stabbing, puts the defendant, who was the white male, over Ryan's body. So putting two and two together, we know that the defendant was actively stabbing this victim based on the eyewitness testimony, but that we have other evidence. We have the DNA evidence. We have the defendant's blood DNA on Ryan's shorts. In addition, if you look at the exhibits, the photographs, this defendant suffered very deep wounds to his thumb and his finger right here, where you would injure yourself by stabbing someone else. And we had testimony at trial that showed that stabbing someone once wouldn't automatically give you those wounds. Those wounds happen when either the knife becomes so bloody that the hand slips down it, or the knife itself hits bone or something else and causes the hand to slip up. The defendant himself, he says he stabbed Billy Ty. That was a superficial wound. He didn't suffer those deep cuts on his finger from stabbing Billy Ty. The Commonwealth suggests that he suffered those wounds from stabbing the victim, Ryan Sullivan, in this case. And Ryan Sullivan suffered 13 stab wounds while he was still conscious.
Now, two of them could have been fatal, right? One to the left chest and one to the left abdomen.
That's right.
And one of them was 7 inches deep and one was 5 inches deep.
That's right.
Now, what did the medical examiner say? Was it that the shorter knife could or could not have caused those wounds?
The medical examiner said that they could have. He could not tell which knife caused which wound because the nature of a struggle, the body is moving, so
Did he say anything that it was more likely to have been he said it could be either?
it could be either. And also because of the force, when you push on someone's body, the body automatically compresses, so it can go in further than when you're measuring it flat.
I thought he basically said, or she, I don't remember which, did not believe that the 7-inch wound, which is only one of the 2 fatal wounds, was caused by a 3-inch knife.
I believe that's in the defendant's brief. I think that if you read the testimony at trial and it was Dr. Zane, it is less equivocal than that. He does say it is maybe more likely, but I don't think he even goes that far. There is no evidence as to which knife caused which wound.
But it's clear that there were different knives used.
There were 2 knives used, the Commonwealth suggests, and the knives were never recovered.
Forensics support that?
They could not say that.
Okay.
But because we know there's 2 people stabbing, the Commonwealth submits there was 2 knives used. The knives were never recovered. The length of the knives were attributed solely to the testimony from the girlfriends who said they have seen knives on these defendants before.
And didn't one of those knives didn't the defendant's knife come from his girlfriend's house?
Claudine, that's right. The defendant's knife came from Claudine. She was carrying a knife, and her testimony was that he took it away from her because he didn't want her to have the knife. So then put a knife in his possession.
If I could turn you to one question with regard to the stabbing of Jules.
Yes.
Was the jury instructed that they need to show that the defendant knew that Jules had a knife?
No, the jury was not, but
That the co-defendant did?
No.
That
the co-defendant.
That the
Van
defendant
Gustav.
knew that Jules was armed.
that Van Gustav was armed. The
I'm sorry, that
co-venture.
Van Gustav was armed, right, I got the
That's correct. No, there was not that explicit instruction, but the Commonwealth suggests there was no substantial likelihood of a miscarriage of justice and would turn you to the supplemental record appendix, page 12, where the judge instructed the jury, in a joint venture, a person is guilty if he or she intentionally participates with another in the commission of the crime as something he or she wishes to bring about and seeks by his or her actions to make it succeed. In this case, we have a stabbing. And if on a joint venture theory, if you have to have joint venture and you have to have intent for that stabbing to occur, you have to know that your co-venture is armed with a knife. Otherwise, you can't have a stabbing. So that knowledge instruction is subsumed within the joint venture instructions. And in any event, this really wasn't an issue at trial. The defendant did not object to the omission of this instruction. The evidence was strong.
The conviction of assault? What was the conviction of?
AVDW SBI, so assault with a dangerous weapon that resulted in substantial...
Was that a lesser included, or was that that as charged?
As charged.
Okay, thank you.
Thank you very much.
And we'll take our morning break.